Alimony, which is the transfer of money from one ex-spouse to the other for some period after a divorce decree is entered, principally is justified based on economic need. However, in some states, courts may consider fault or marital misconduct in determining an alimony award. In Dykman v. Dykman, the Arkansas Court of Appeals considered whether fault could be considered in an alimony determination if it related to the need or ability to pay alimony. Roscoe and Kathryn Dykman were a married couple from Arkansas. Roscoe was 85 years old and a doctor of psychology. Kathryn was 52 years old and a psychiatrist. Kathryn had worked for several years at a consulting firm. In her role, she earned up to $12,000 a month and gave most of the money to Roscoe with the understanding that he would use the money for marital purposes, including paying down the couple's debt. However, instead of putting the money toward marital purposes, Roscoe used the money to buy lavish gifts for various mistresses he had. In 1999, Kathryn sustained an injury that caused neurological damage and her speech to be interrupted. Following her injury, she was fired from her job at the consulting firm. Kathryn then sought to open her own psychiatry practice because this would give her the ability to take on more of an administrative role, which she could do with her medical condition. Subsequently, Kathryn filed for a divorce from Roscoe in state circuit court. At the time of the divorce proceeding, Kathryn had no income because she had yet to establish her psychiatric practice. At trial, evidence was presented that Roscoe placed a snake in a box on Kathryn's driveway with a note that stated, quote, "Die, bitch," unquote. In addition, evidence was presented of Roscoe's extramarital affairs and the funding of those affairs with marital assets. Following trial, the court ordered Roscoe to pay Kathryn $1,023 a month in alimony. Specifically, in ordering alimony, the court considered Roscoe's misconduct as relevant to the alimony determination. Roscoe appealed to the Arkansas Court of Appeals.